Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book from Bloomsbury Professional. It's a very important book because of the way the global economy is going at the moment. It's now in a third edition and it's called Cross-Border Insolvency, and the general editor is Richard Sheldon QC. This is the book here. You can see the front cover, and you can see the number of people who've contributed to it. There's the spine at the side. The general editor is Richard Sheldon, as I've said, and the contributors all come from South Square. So it's quite important to know that it's basically a Chambers book as much as anything else. There's the actual preface from South Square Gray's Inn. And Mr. Sheldon sets out very clearly what the book's about. Useful abbreviations and contents. You can see a few more about the contents there. The book itself is structured in the normal way, where you've got paragraph numbering at the sides, and you've got quite detailed footnotes, which you can probably see at the bottom there. At the back there's an index, which is not too big, but just about manageable, I think, frankly. And what I have liked about this particular book is there are two important appendix. Appendix A, or 1, is dealing with the European Union matters. I'm just getting to it at the moment, which is just here. You can see the regulations from the EU. And then Appendix 2 gives you cross-border insolvency regulations. Very important indeed. The book, as I say, is a heavy book. It runs to something about 600 odd pages. We've written a review, my wife and I have written a review, which is appearing on the web and in the journals, and we've given it the title Expert Guidance for Cross-Border Insolvency Practitioners. This is what we say, with many businesses having gone global, the problems of insolvency are compounded and magnified when the issues that emerge extend across borders. And yet Richard Sheldon QC, the general editor of this important work, and his colleagues in Chambers point out that the law on cross-border insolvency began its evolution as early as the 18th century, with the then spectacular growth of international trade. So not a lot has changed, but we've now got, of course, a lot of regulation which has come in as part and parcel, of course, of the expanded role of the EU. We were particularly intrigued by his account of the landmark decision in Solomons and Ross in 1760, when among a number of events, the wonderfully and appropriately named Chamber of Desolate Estates in Amsterdam appointed curators, that's assignees, of the debtor's property in the case. For further details you need to acquire the book, but it's interesting to see a case going back such a long way. So this book deals with the full spectrum of issues pertaining to the subject, from the UN Citral model law to jurisdictional issues, to enforcement of judgments and orders made in foreign insolvency proceedings, to matters of priorities and set-off, and of course much more. Set-off is right at the back, by the way, of the book. Significant changes to the law since the second edition have been incorporated for this new edition, and in addition to the number of new chapters, there are many that have been rewritten to reflect recent developments. The contributors to each meticulously researched and footnoted chapter are clearly identified, and each presenting an individual view. In view of the string of high-profile and notorious insolvencies in recent years, such as Maxwell to Madoff to Barings and Lehman, the publication of this up-to-date edition is timely. So be you an accountant or lawyer or a consultant involved in cross-border insolvency, this book actually does belong in your professional library. I'd like to thank Bloomsbury very much for taking this on and producing it, and to the very hard work of the members of Chambers, because it's an important area as we look to the second decade of this century and how we're going to sort out what is a really serious international economic mess. Thank you very much to all concerned. Bye-bye.